Hey guys, Gary with another legal tip. What happens? Can the seller choose the lender or the attorney that the buyer has to use in the closing? So this is a question we've been getting more and more these days. The question used to come only because of builders. In a lot of builder contracts, they would put in there the buyer agrees to use their closing attorney, the buyer usually use their preferred lender, and things of that nature. And so people would ask questions about that. But now what we're seeing, because the market is such a seller market, is that sellers are starting to put things in their contract saying that they will sell the property only if the buyer uses this lender or the buyer uses this attorney or they don't use VA loans. And so the question is this legal? Can we do this as agents? Are we at any risk in this? And so we have to look at a bunch of different things. Now, the reason that sellers are putting this in the contract is when they have multiple offers, they want to ensure that the person who's buying their property is actually using a lender that they know of, they've heard of, they've trusted, not some crazy credit union from some far off land that they've never heard of. They want to make sure that it's a national lender or a good local lender that they know of. And that way they have more comfort in knowing that, yes, these people will be able to close. And if this lender's telling me this is a pre-approval letter, I can take it to the bank. The reason they also want to use their own attorneys is that they trust this particular attorney to do these particular closings and to handle it the correct way, versus them maybe finding that the buyer having a brother-in-law that's really a litigation attorney, but he's going to try to put together a settlement statement and try to get the closing done. And so that's what they want to avoid. And the same thing with the VA, they want to avoid the VA appraisals and things of that nature. So the question is does this violate law? So we have to look at 40-57, 710, number 13. It says that an agent may not, could be punished for violating a provision of law relating to the freedom of a buyer or seller to choose an attorney, insurance agent, title agent, or other services to facilitate the closing. All right. So first of all, what are you doing that's violating that? The answer is going to be nothing. The second, we look at the Code of Ethics, Article 6 says if you financially benefit, then you have to disclose it. So unless you're somehow financially benefiting from this lender or from this attorney, then there's no issue. Now, if you're one of those agents that have a brokerage that has sold its soul to a lawyer and you're splitting title insurance, and so all you do is provide the client to the attorney, and then the attorney then shares the title insurance with you, which we believe is a violation of state law. But if you're doing that, yeah, there is a financial benefit for you pushing that. So that could be a problem for you. But more importantly, talking about our topic today is there's nothing there that violates that. The parties can contract to let whoever they want be the closing attorney. The parties can contract to whoever they want to be the lender. In South Carolina, the only law that we have that prohibits provides the buyer the opportunity to select the attorney is that the lender may not say as a condition to getting this loan that you will use this law firm. That's all. It doesn't say that the seller can't say as a condition to buying my house, you will use this law firm or you will use this lender. So there's nothing that's illegal about it under the law. So therefore you don't violate 40-57, 710, because in order to violate that, you would have to violate a provision of the law, which there is nothing that you'd be violating. And it doesn't violate the Code of Ethics unless you have that financial benefit. You're one of those real estate companies that have sold your soul, as I've said, to a lawyer to share title insurance, which there's a couple of them in town. So outside of that, there's really not any violation. There's no lending law that violates it. So it is proper for a seller to say, I only will sell this house to you if you use this law firm or if you will use this particular lender. It's a contracted provision. It's properly legal. Hope that answered your question. If you have any questions, reach out to me at Gary@Blair-Cato. Don't forget about signing up for the April 7th event for the Real Estate Success Summit. Tickets are almost gone for that, as well as check out this week's podcast. Links are below. Take care.